You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 112. Can I use a provisional patent application to stop infringers or stop people from stealing my invention? My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T patentlaw.com, or call me at 424-281-0162. I'm on several inventors groups online, and people post questions, and then other people post answers, and lots of times there's bad advice because, surprise, people on the internet don't know what they're talking about. I'm going to go over a question and answer right now, and the question was, if you come up with an idea that is easy to knock off, would it be worth filing for the provisional patent application and then letting it expire, but not filing for the patent? That way, at least someone trying to rip you off doesn't have the chance to file a patent on it and go after you for infringing in the future. Assume you wouldn't have the funds to sue for infringement if you were to own the patent. Let's take this question apart step by step so everyone knows the terms. A provisional patent application is a kind of patent application that never turns into a patent. If you file one, you have 12 months to file the real or a non-provisional patent application. And if you do that, it's as if you had filed your real application on the earlier date of your provisional patent application. Now, there are lots of caveats to this, so listen to my episodes about provisional patent applications. If you don't do anything with your provisional application within 12 months, it's as if it had never been filed at all. It doesn't get published, it doesn't get examined, it's like it doesn't exist. Now, in the first part of the question, they want to know if they can stop people from making their product if you have a provisional patent application. The short answer is no. You can't even stop someone from making your product if you have a non-provisional patent application. You can only legally stop someone from making or using your product or invention if you have an issued patent. Until it's issued, you can't sue for damages and make anyone stop. The best you can do is put patent pending on your product and hope that it will scare off a few people from making knockoffs because they know it might turn into a patent. The other thing that you could do is send out a letter to the party making your product and just warn them that you have a patent application on file, and that if it issues into a patent, they could be liable for damages all the way back to when you notified them. There are all kinds of rules about when you can get past damages, but it's possible to get back damages from before your patent issued. So really, a warning letter and putting patent pending on your product are the only two things you can do if you have a pending patent application, whether it's provisional or not. The next thing the person wanted to know was about someone else filing a patent application after you filed your provisional patent application. There are a couple things here. If you file a provisional patent application and then you start selling it or making it public in some way, those sales and public disclosures can't be used against you for your own patent filing. But if you file, and that's if you file your real application within 12 months, but those 12 months don't apply to someone else. So let's say that someone came up with the same invention, and maybe they copied you, maybe they didn't, maybe they just came up with the same thing on their own. If you sold or disclosed your invention even one day before that person filed their patent application, that other person cannot get a patent on it because it's considered the public domain. Now, let's say that you filed a provisional patent application and you didn't sell it, you didn't make it public, but someone else filed a patent application for the same thing. Are they allowed to do this? Well, it depends. If they came up with it all by themselves and didn't copy it, then yes, they can get a patent on it. And that's because there's nothing in the public that could be used against them as prior art to reject their patent application. But you're thinking, what about your provisional patent application that was filed earlier? Can't that be used against them? And the answer is no. Provisional patent applications aren't published, so they can't be used as prior art. Now, if you filed a non-provisional patent application that was based on a provisional, and that non-provisional is published, then yes, it can be used against them. But there's another issue. If this other person that filed this patent application for the invention that you did, are they allowed to do this? Assuming that they copied it from you? And the answer is no. You have to be the inventor in order to file a patent application. When you file a patent application, you sign a declaration stating that you're the inventor, and if you're lying, there's a fine and up to 5 years in jail. Now, let's say that you saw an application was filed and you know this person stole your idea and they're not the inventor. What you can do is file what's called a derivation proceeding, and the Patent Trial and Appeal Board will decide on who the inventor is. It's like a mini trial, and you have to submit evidence that the invention in the patent application was derived from you. So in the end, if you go through this, you can be listed on the patent instead of the person that stole it from you. Now, there are other things you can do besides that, but that's the main thing, and there are lots of rules that I'm not going into about derivation proceedings. Let's look at another scenario. Let's say that you came up with an idea, you filed a provisional application, and you let it expire, or maybe you didn't file one at all. Then someone comes along, and they didn't steal your invention, but they came up with the same idea all on their own, and they got a patent on it. Can they sue you for infringement even though you came up with the idea first? And the caveat is that you did not make it public, but you came up with it first, and somehow you can prove that you came up with it first because maybe you filed a provisional patent application, or you have some other documents that you can retrieve that shows that you came up with it first. You might not be able to invalidate their patent, but they maybe can try to go after you. And that's really the question. You came up with it first, they have the patent and they legally can have it. Can they still go after you? And that's a really good question. And this came up not that long ago with Congress, because let's say that you are a business that uses some secret technology and you don't want to get a patent on it because you'd rather just keep it secret than having a patent out there and other people can see your secret technology. You just want to keep it as a trade secret. But then what if some other company comes along with that same technology and they decide that they do want to get a patent on it? If they get a patent on it, does your company have to stop using the technology even though you've used it for years? And there didn't used to be a clear answer, but the answer now is that generally you cannot be sued if you're a prior user, whether you filed a patent application or not. This is called the prior user rights defense. There are lots of caveats to this. First, you have to show that you were a prior user more than 1 year before the filing date of the patent application by the other party, or the date of the public disclosure by the patent holder. There's a lot of legal language in there and details, and if you want to know all those details, it's in 35 U.S.C. Section 273 of the America Invents Act. How are you going to show that you are a prior user? Well, maybe a provisional patent application filed with the patent office would be a good defense. You used to hear people talk about mailing something to themselves to prove that they invented something, and they call this the poor man's patent. Don't do this. That especially is not good now that we're in a first inventor to file system. It was never a good idea, but now it's even a worse idea. But you can file a provisional patent application for what's currently either $75 or $150 probably for you. And at least you have something on file with the patent office showing that you believed you invented something even though you never did anything with that application and it goes abandoned. Now, technically, the way that I'm reading the statute, you only get the prior use defense if you're commercially using it. And filing a provisional application doesn't show that you're using it. It just shows that you thought of something. So it's probably not good enough by itself, but it's not a bad piece of evidence to have if you're trying to show that you were using this invention before the other party filed their application. So the main point is that you should be allowed to continue using it because you were using it before they even filed their application. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.